All right, well, I believe that our participants are ready and for our presentation. Thank you everybody for joining us. I'm Jennifer Skolnick, co-chair of the Family Law section of the Beverly Hills Bar. Just wanted to tell you about a couple of webinars coming up for the Family Law section before I throw it over to our panel. On Monday, which is next Monday on May 18th from 1 to 2, we have a webinar talking about family law disputes under COVID-19 and mediating with virtual technologies. We're going to have Judge Hank Goldberg, Woody Mostyn, and Mark Baer on the panel for that. And then on June 3rd from 6 to 8 p.m., we're going to have our third annual Meet the Mental Health Professionals Night. This is going to start off with a panel with Judge Diana Gould-Saltman, Alexander Leiter, and Dr. Susan Rempel, who will be discussing the various roles of mental health professionals in resolving family law disputes, as well as how they can help resolve or help us resolving family crises during the mid and post-pandemic world. Following our panel discussion, then we'll have the mental health professionals who will get up and introduce themselves briefly and discuss the roles they play and their areas of expertise. So don't miss that. We typically have a very good turnout with the mental health professionals. It's a great way to meet people that can help us on our cases. So, and then we have some other great webinars coming up through the Beverly Hills Bar. Make sure you check the calendar for other great programs. Our program sponsor for today is White, Zuckerman, Warsavsky, Luna, and Hunt. So thank you, White Zuckerman, for sponsoring. And thank you, panelists, for putting together this program under a very short time. And I'm going to turn it over to you, Brian Lepak, the moderator.
Thank you, Jennifer. What we're going to do today is just have a general discussion on financial issues. We will try to address the effects of COVID in 3 different scenarios. That would be 3 different types of businesses. One would be a small retail business, such as a nail salon or hair salon. Second would be a professional practice. And a third would be a food service type of business. But before we get into discussing those types of scenarios, I would like to start out by wondering or addressing whether we're making too much of this whole effect of COVID on financial issues. I know the stock market crashed at the beginning of April. They say when a stock market crashes, it takes the elevator down and steps up. But as we've seen, stocks took the elevator back up recently. So isn't the... For now. But isn't the economy, Your Honor, going to recover real quick, just like the stocks did?
You know, I've been doing all of my deep analysis into the Nike swoosh, which is one view I've heard. I've heard the checkmark view. I've heard the inverted V view. And here's what I know. I kind of like what Jackie Mason said. I saw him at the Wiltern some years, or it was the someplace in Beverly Hills. He's fabulous, of course, if you don't know who he is. And he said, you know, my brother-in-law is a stock market, but he's broke. And I asked myself, why the hell should I listen to him? And so I think that what the market is telling us is that there's a great deal of uncertainty. And my speculation is no better than anyone else's. If we go back historically, what we know, for instance, when cities were faced with the Spanish flu, which started in Kansas, how it got the name Spanish, I have no idea. But in any event, Los Angeles was one of the first cities to go into what we're doing now, basically businesses shutting down and social distancing. And they were one of the first adopters. And what does the research show us? The first adopters in the Spanish flu era were the first recovering units by city and location. So the fact that we shut down early may be, relatively speaking, beneficial for California. And plus, frankly, it's hot here in California in many spots. The reason they call it cold season is because those viruses like it cold. If being in a cold environment meant that you were going to get a virus, then as my doctor once said to me, Eskimos would always have a cold. So it doesn't have anything to do with the temperature, but the temperature does deal with the viruses. What do we know? Well, we've seen a resurgence in China, probably airborne now for COVID-19 or coronavirus. COVID-19 is the disease, the virus is corona. And it looks like it's mutating into airborne. Not to scare all of us, but just to be practical, I don't think anyone's opinion on what it's going to look like a year from today is worth much more than the speculative argument that Jackie Mason made with his brother-in-law. Why should I listen to you? And so I don't even think the economists are in agreement on what the future looks like. But here's what I know. Family law is extremely resilient. And family law this is not our first rodeo with difficult economic times. We went through the 06-08 recession, the Great Recession. I don't know if anyone who's watching went through the Depression or would admit it or can remember or any of the above. But we also had a terrible recession, I want to say, in the late 80s, around 88-ish or so. Took several years for that to recover. We wiped out 4 years of employment in less than 3 months. So I just think there's a tremendous amount of volatility and uncertainty. But we have cases that have dealt with difficult economic times in valuing companies. As I said before we started, I think that this is probably a better time than ever to look at what was the economic world looking like at the time that the district courts of appeal wrote their decisions. Because the idea that the court is not influenced based on what's happening economically is naive, frankly. Here's a good example. We have one case that says if you save beyond your needs, we can consider that as income for support. But if you credit card your needs, we're not going to consider debt as part of income for support. So it's not like they are living. We may think they're in an ivory tower. They may think they're in an ivory tower. I think the building is only 5 stories high. Reagan building, I don't know. It could be wrong. They don't know either. So I think it's going to take a little while. The biggest problem is going to be the restart of the economy. So what did we see yesterday? I think we saw some notices that maybe we're not going to reopen Los Angeles County until July. So I say we look at all the various options, whether it's looking at what the cap rate is going to be because risk is so high right now. Who wants to go out and buy one of these small businesses other than somebody that's going to be a liquidator? Probably no one. Nail salon, who wants to buy one of those? There's probably a dime a dozen right now. So I think it's too early to tell. That's a long answer, but that's really where I think we are.
I think that's a very important issue. This uncertainty that we're facing affects the issue of reservation of jurisdiction that we can be discussing with respect to support or valuation. Do we, in fact, put a pause on trials that deal with financial issues until the end of this pandemic, or do we proceed forward and just take whatever hits there are that this COVID-19 issue is going to place on the valuation of businesses or on the amount of spousal and child support? So if it's going to be 3 years before any recovery, reservation of jurisdiction is going to be almost impossible. However, if it's something much more immediate, perhaps within the next 3 months, as you say, Judge Lewis, the economy is fairly resilient and things could recover, and then we could get to more normalcy and do the trials, postpone the trials until a date certain, and perhaps the courts can use a 3-month benchmark for reservations of jurisdiction, rather than say until further notice. So here we're going to continue this trial for 3 months. When at the end of that 3-month period, if this situation has not significantly, then maybe go another 3 months and play it by ear. Everything that seems to be going to a facts and circumstances test under the current conditions. I know that's true in so many cases that I have. I think Drew wants to add something.
A segue to your comments, Jack, would be as follows. I think the whole issue of reservation of jurisdiction is a must. It may not be able to go on forever, but it depends on the type of asset and the type of the market segment that the business is operating in. Let me give you an example of the type of asset. So, for example, if we're talking about the family residence right now, there might be multiple properties, and the parties may have a desire to award a certain property, but they don't want to value it today. The real estate market may, in fact, stabilize quicker than the business market. So if we did a reservation or an agreement to award a property with a future date evaluation, let's say 12/31/2020, so that the market has time to stabilize and that some market comps can be generated in the marketplace, that might be one thing. It may be also depending on the type of business you have. There are some businesses that are going to recover very quickly. Leveraging Judge Lewis's comments, whether you have a V recovery or an L recovery or a W, we hit a double recession, depends on the type of business. The economy does not fall or grow in simultaneous equal rates. So depending on the nature of the company, you may be able to say, we are going to reserve valuation until 12/31/2020. And by the way, realistically, I think we all realize we're going to be stuck with dates into next year anyway if we're going to trial. But other business, depending on if it's a new restaurant or an existing one that has barely survived, you may need a longer period of time that isn't realistic for the court to reserve on. And then you have to get into what are your alternatives there.
So how does the court do that without violating its obligation to divide divisible assets and value them at the date of trial? And what is the date of trial then under that scenario, which I'm not saying it's a bad idea. I'm just saying playing it out to the next step. I'm the bench officer, and of course the operator spouse. You know, the strategies here are going to be all over the place.
Yeah.
You know, would you buy stock in a company that managed 300 nail salons and 400 ma and pa restaurants? I wouldn't.
No.
Because most of those companies operate on pretty thin margins, don't they, Jack?
Yes, they certainly do. And you know, with respect to restaurants, of course, the margins are higher in the liquor side of the business, and maybe as a result of the
yeah, we're all home drinking more now.
Spike in income, but all kidding aside, there are some instances, I think, where the trials on certain issues can be held currently.
Yes.
For example, the issue of child support, it's so important that, especially in situations where one spouse has the means and the other doesn't to feed the children, to have an adjudication of that issue. And the guidelines are not going to be as relevant moving forward as they have been in the past. Looking at Section 4.
Guidelines for support, meaning?
The child support.
Yeah. So I have to tell you, they're always going to be relevant because the court must make a guideline finding, as we all know. Marriage of Huebner makes that extremely clear. The question, I think, Jack, is going to be, are we going to start to deviate from guideline, upward or downward?
That's exactly what I was going to.
I'm sorry, I jumped the gun. I apologize.
You're absolutely right. Under 4057, there has to be a guideline calculation. But there is that 4057B, I think it's B5, which is special circumstances, which may be, it was used in the Cryer case, as you all recall, and if you need the site on Cryer, it is.
I can get it.
I have it right here. 198 Cal App 4th, 1039. But I've rarely seen it used in many of the appellate cases. But I can see where, rather than going to guideline, you don't have to be a high earner to use this. It can be a situation where the supported spouse can present a children's needs analysis to a husband who has perhaps the means to pay for the child support despite the lack of current income. Much like the DeGueen case, for example, where Mr. DeGueen was very rich and he was selling off parcels of his real estate in order to feed the family and pay for all the living expenses. So what do you think about that, Drew? Do you think you'll be employing that type of technique?
Well, first of all, in a big majority of our cases, and we've already experienced that, we have clients who have no income anymore. It may be
living on assets.
Right. So the question is, yes, you have to have a guideline number, but if you have no wages and you have no business income, then you have no guideline support, whether it be child or spousal. So you are going to have departures from guideline support. There's no question about it. The solutions I am taking on my cases right now that I am recommending, whether I'm the 730 or a joint or just working as an expert for one party, is if we have no income, we have to do what we always do. We have to look at what are the parties going to do to meet their expenses right now. Each party is going to presumably be buying food, paying their rent, paying their mortgage, what have you. So we have to look to a pre-distribution of assets. And beyond that, we could, in my view, come up with a temporary support order if we're talking about a pendente lite order. And then I think we automatically set into place a review hearing. And we should do that even on a permanent order so that people don't have to file motions to modify. We're gonna do our best, gauge what is likely happening now and what might be happening in 3 months or 6 months, and say here's what we're gonna do, and we're gonna come back and we're gonna review these issues and see how things mature and stabilize. And frankly, I think that's much better than making people come back and modify support and having to fight for a change of circumstance.
What do you think of our remarks, Judge Lewis?
Well, I think number one,
Can we address Gruen while you're talking as well, maybe?
Yeah, that's what I was going to say, is Gruen. First of all, the court must make an order. Second, if the court makes an order and the matter is completed, and that's the key operative word, it's kind of a word of art, if you will, in the way cases are diaried in the court's system. Completed, meaning I've made an order, the matter is complete. If I make that kind of an order, then I cannot just say, and I'm going to reserve jurisdiction to retroactively modify it. It's an oxymoron. If I follow Freitas, then I can say I'm going to make an interlocutory order, which, by the way, for those of you who don't like interlocutory orders, you're going to like them even less since they're not appealable, but they are writable. And I think that the appellate attorneys who do family law can confirm that if the court makes an interlocutory order and reserves jurisdiction to reclassify it, reallocate it, mix it up one way or the other, then your remedy is writ. Now, so who's going to take a writ over 3 months of support that's too high? Probably not going to happen. So in Freitas, the court reserved jurisdiction because it wanted to know more information. And part of what it also learned, of course, was that husband was the perpetrator of DV, which didn't help him much. But if you're going to be asking the court to do something and reserve jurisdiction, I think that's a better sell. And by the way, don't go into court and say, well, Judge Lewis says you should do this. Judge Lewis never said any judge should do anything. I'm telling you as lawyers what arguments you should be prepared to make, and those of us who are on the dark side, if you will, have to be prepared to address. So reservation of jurisdiction, one great alternative. 2, trials. I'm not sure that the court can, what's the point of the testimony? Now, correct me if I'm wrong, Drew and Jack, but am I correct to say that in calculating value of a business, we cannot consider future earnings. We can only look back in time at historical earnings to determine valuation. Is that a fair summary of that little narrow issue?
Yes, I mean, the old cases, I think it was 5118 was the old code section, which stated that post-separation earnings should not be considered in the valuation of the business because they're separate property. And that has really been the hallmark of our valuation approaches. Every forensic accountant that I know always uses historical income and then adjusts that historical income by two factors. One, the risk analysis, and that's reflected in the capitalization rate that we use in our appraisals. The other is weighting of earnings. How relevant are historical earnings? Maybe there are some years that are relevant and we could give greater weight to those years and less weight to other years. But we have techniques by which we can adjust the discount that we want to impart on a particular business that is currently having a significant downturn in revenue. What do you think, Drew?
Well, first of all, let me tell you what the real world does, and that what we do in family law is different, right? We're confined to different standards in our venue. When you look at what happened to the stock market between early March and when it hit its low, it dropped by 38%. Corporate earning projections in the public marketplace dropped by 30%. So why the 30% drop in projections, which is 38% drop in value? Because Jack has hit on it. It's a component of two things. Future expectations of earnings drive value. And
Buy on the dip, not on the top of the mountain.
Right, and the other thing is the certainty of reaching those projections. So two things happened when COVID took over. Now I call it the COVID economy. What happened was you have uncertainty as to lower earnings. So the earnings are projected even lower, but the value dropped even beyond that because you have uncertainty. The market hates uncertainty. The market wants certainty. The more uncertainty, then the more risk that one perceives in investing in a company, and the more risk, the lower value, other things being equal. So what we have here is something very unprecedented. And when we are looking at our valuations in family law, we tend to look backwards in time. We look in the mirror and we try to come up with something that says, this is a normalized adjustment. If you want to read the best document you can on business valuation, always go back to Revenue Ruling 5960, because it is the seminal document in understanding what we do as appraisers. In that 5960, it talks about the ebb and flow of business valuation and ebb and flow of economic cycles. Well, we're at the bottom right now. And so when Maybe. I hope we are at the bottom. We don't know.
Me too.
But when we are talking about Jack's comments about normalized earnings, yes, I mean, what are you going to do in valuing a company when we are confined to the history, but when the market and everybody else looks to the future? And so we try to make adjustments to normalize historical earnings, and we may make an adjustment for lower profit margins now because of COVID, or we may make adjustments for lost significant contracts or having been shut down for a period of time. And I think Judge Lewis will agree that if an expert was in front of him and made one or two reasonably and rational adjustments, he might say, yeah, that makes sense. But what we're looking at today goes far beyond that potentially. And if the expert comes in and makes 10 or 12 adjustments to the historical earnings, you really have Frankensteined the historical earnings. They don't even look like that anymore. So there's a desperate need to do it, and yet it's going to open up that crazy Wild West. What are we doing here? There's so many changes. I don't know if they're no different than somebody's wild projection. Then what do you do, Your Honor?
And
Well, of course,
how are you guys
I make you do
credible
a
if we
side by
don't-
side.
How are you guys credible if you don't know the future and you can't predict and we don't know? How are we going to rely upon what you're telling us?
I don't know.
Well, that's why you're going to file an RFO to modify.
But the only thing I can be prescient about is that we'll be doing more evaluations based on liquidation value than on investment value.
Right. You know, an interesting business area that we haven't touched on. So I'll touch the third rail of politics now that I am in the private sector again. In the socialist state of California, in the state of California, they have told landlords that they cannot evict people. And I'm just wondering, when did that hearing take place? As far as I know, it took place in the minds of our conservative legislature to decide that, you know, people don't have to pay rent and there's nothing you can do about it. And hearing? Oh, what hearing? And borrow money against your now apartment building where half the people aren't paying any rent, or all of them aren't paying rent because they figure, what can you do to them? You can't evict them. You can't get to court. Who's going to loan that guy any money? No one.
Yeah.
No one.
It's
So
definitely a factor we should consider as a real estate appraiser, certainly. And we don't do real estate appraisal, but
no, but you do income available for real estate developers. The developer world, I think, is looking a little different today based on, you know, we'll finish the projects we've got, hopefully, before our construction financing takes over the project, if you will. So I think that the smart move right now is this. First, you have to plan for when are you going to actually get to court. And as self-serving as it is, the public court is going to be, I think, and I hate to say this, I wish I was completely wrong, but I think it's going to be 2 years before they're going to be able to stabilize what's happening in the family law division. As capable as Judge Riff is, who I adore and have great respect for, he can't change the reality of 120 days of filings that have backed up, that haven't been heard. Another 120 days. I was telling my wife, Chris, last night, you know, if we go 6 months, here's your Jeopardy question. What is 45,000? 45,000 is the number of new family law filings typically filed in a 6-month period. So that says nothing of the existing family law cases that are already out there, or the cases that are going to percolate up because people have flocked to Brian's office because there's nothing else to watch on Netflix, so we might as well get a divorce. And you know, so there's going to probably be a uptick in new filings, and so I think you have to have a strategy with opposing counsel. I think you need, if you're going to settle your case, boy, do you need lots of disclosures and buyer beware, seller beware, lots of recitals about what led the parties to make this agreement. Because I can see this, you know, he said the business was going in the toilet, or she said the business was in the toilet. And then suddenly there was a new government program and the business is perking along like ever, and he never told me, and he breached his fiduciary duty, and I want to set that judgment aside. So recitals, I think, are more important today than they ever have been, and they've always been, I think, the at the top level of importance when we're addressing agreements and whether or not they are subject to being set aside. Making a bad deal alone is not grounds to set aside.
Can I follow up on that comment?
Yeah, please.
2 things. One, I want to make a comment, and then I want to follow up on it. Going back to my comments on making these historical changes, I think not only is it going to be more complicated, you may have to bring in or consider bringing in economists or industry experts to supplement the testimony of the forensic. But that's going to get complicated, and it's certainly subjective, and it's going to be expensive. Now, I have a question for the panel. I don't care who answers it, but let's just say there was a stip in order or a stipulation or some kind of agreement to do an alternate valuation date at 12/31/19, and the valuations have been done, but there's no agreement, and the trial is going to be heard in 2021 or 2022. And the metrics and economics have vitally changed because of COVID. Now, what do we do with that stip in order? Can it be set aside, or what happens with that data valuation at this point under 2552, Your Honor or Jack?
I'll leave it for Your Honor.
Thanks. Well, I'll give you a good judicial answer. It depends. How's that? So here's my answer for you. I think number one, entering into any stipulations right now about data valuation, it comes with an awful lot of risk. But that's what the litigation world is all about, the cost benefits analysis. So just because the economy is worse doesn't change the metric by which you advise your client. So for instance, if you have the out spouse, you say, look, that business might turn around and do very well. If you've entered into a stipulation and the business has been essentially destroyed, then maybe you've got the Olson case and the statutory provisions that are available. One of the Olson cases with SON, OLSON, dealt with a home that was foreclosed on, and then on remand, the question was how to value it. We have a case from last year where the court decided to sell all of the property. So, I could see a business owner coming in and saying, I don't want this business. I've got to go find something else to do. I just enrolled at the, Santa Monica City College for online courses to learn how to do something different because I don't think I have a business when and if I ever reopen. So I think the motion to set aside based on facts that have transpired that are not in the hands or control of the business owner. So this is clearly an era where closing up the economy of the world for 90 days, I don't think we did that in World War II. We repositioned what we spent money on, and there was lots of rationing and whatnot. And some of us are even old enough to remember when we had to fill our gas tanks up on an even number or odd number day based on our license plate. I can remember that. So I think it's going to be very fact specific, and also this. So you entered into that stipulation to value on December 31st of 2019, and now you're doing your trial in January of 2022 or 21. Let's be optimistic and say 21. Not going to happen, but let's just be optimistic. What does the economy look like then? Does that look like a really bad deal or a really good deal?
And how much did the business owner contribute to making that business increase in light of what happened after COVID?
That too. By the way, because of the importance of the Olson case, I think that Judge Lewis brought up, I'd like to give the audience a cite. It's a 1993 case, 14 Calop 4th 1. As an aside, one of the possible methods or procedures that people can employ with respect to the businesses that are no longer worth what they were worth at 12/31/19 is what's sometimes called ride the tide. In other words, just divide the business in half until such time as one party decides it's time to get out, and then
make them tenants in common, essentially.
Exactly. So
you would have to fight against the Knickerbocker case. So the Knickerbocker case says that the court should avoid making orders that unduly entangle divorcing spouses from having to deal with one another. So that argument, by the way, was made in Honer, Honer. In Marriage of Honer, wife wanted to stay in the business. And for a lot of reasons, and shocking as it may seem, husband did not want wife to stay involved in the business. He said, one of us or the other of us, but not both of us. And the court went with him as the operator spouse.
Well, under the current set of circumstances, maybe there won't be any entanglement if the business is dormant during this.
Well, that's right. Yeah, that's right. You got nothing to lose because you got nothing.
Right.
Fair point. Very fair point.
Perhaps the facts and circumstances might be ripe for a new type of resolution.
Let me raise a question. Assuming a valuation date is going to occur in 2021 or 2022, as the case may be, and because of the delays, and I'll throw this to you, Jack, and then Your Honor, what do you do with 2020 results? Okay, typically, if you're looking at a representative period for support, or if you're looking at normalized earnings for evaluation, and you see a precipitous drop in revenue and profits, and maybe you see it coming back in early 2021, you just ignore that year, or do you believe that this kind of thing is now a new inherent risk that should be given some value? What do we do with that?
Well, since you addressed it to me first, let me tell you my thoughts are that when it comes to spousal and child, there's a difference. With respect to child support, I think the needs of the children are the first measure that should be taken, and all facts and circumstances relating to that issue should be taken into consideration. So the wealth of the relative parties, even the drop in income, the needs of the children, of course. So ultimately, if it's a child support case and there is no serious income to provide sufficient guideline child support, then one of the parties should put together what they perceive to be not necessarily the most extravagant needs of the children, but a reasonable amount of needs, and maybe at the lower end, to bring some kind of rationality to the forum. You can't go in and shoot for the moon under these circumstances, but you need to get something. And that something is not going to be guideline child support. With respect to spousal support, same thing applies. The marital standard may not be relevant anymore because it's well above what either party can afford or the supporting spouse can afford in particular. And so a more, I should say, a less affluent marital standard, or a more modest marital standard should be a presentation. And if one of the spouses does have the assets to support that, then perhaps there's a partial distribution of community assets with a reservation of jurisdiction as to whether that would be something that the supporting spouse can get back with them. So that's the way I would look at those issues.
What about in a valuation? When you're looking at, let's say you're in the year 2021 and you're looking back to 2020, 19, 18, and 17 in your valuation for normalized earnings. What weight are you going to give to 2020 is what I'd like to throw out there. Is it considered a nominal, an anomaly or aberrational, and we give zero weight, or do we factor it in saying it's a new inherent risk? We don't know.
Well, considering that we cannot tell what the future will hold with respect to COVID-19, if it goes on for 3 years, then whatever measure we use for weighting that 2020 will be wrong. And similarly, if it only goes on for the next 3 months, it will be wrong, because there's no way we can predict that. Hence, anyone who accepts valuation at this time, firm valuation at this time, is kidding themselves. I don't think we as appraisers are in a position yet to assess the risk. And until we can assess that risk accurately and reliably, we cannot provide a reliable appraisal. I mean, that's the bottom line. It has to be reserved to a time when we have sufficient economic information from which to draw on in order to render a reliable opinion.
Can we address the Riddle case maybe about now, Your Honor?
Yeah, I think that's exactly where we are. I was going to comment earlier that, I think it was Solomon who said, he's a judge back in the day, he said that there's nothing new under the sun. And so there is nothing new under the sun. The elegance of most of our decisions is that they are so well thought out, unless, of course, they've reversed a judge that I like, then they're usually not very well thought out. But when that does happen, the Court of Appeal can write some very elegant decisions, and Riddle is a perfect example. And one of our forensic colleagues called it the Riddle, which is just such a great play on words. What is reasonable? What is representative? And I'm sure that the participants out there wish that we had, the answer on all of these things. We don't. What we can give you, and I think we're trying to, are the things that you should be mindful of and prepared to argue. And so I think that it's going to depend on the industry. So for instance, if you're a small seller who has been picked up by Amazon Prime, and Amazon Prime is letting you use their box and their tape to ship your goods under their umbrella, then you might be in a situation where your business is doing very well, quite frankly. Zoom would have been a great stock to buy in November of last year. So was Amazon, frankly. Knowing what what is normalized earnings, this is an aberrational time. And just like if we had an enormous single sale to one customer of the $15 million yacht that'd be a cheap one, $100 million yacht that we built in Ventura and sold it to somebody in Newport Beach, and we made the sale. Well, it took 4 years to build that yacht. So we're not going to say, oh, gee, that's a year in which all the income is received. We've got to look at it over the period of time that it took to manufacture the doggone boat and then spread that out over time. So I think, go ahead, I'm sorry.
Just like construction accounting.
Yeah, like construction accounting, right. And, as well, when it comes to making temporary orders for support, I want to just add this other little argument, which I think can be made. Your Honor, Judge Lepak, there is no income here for my client to receive child support. As you know, the parties have the ability to borrow against their 401k for emergency purposes, and I'm asking you to order the participant's spouse to take a loan against the 401k, borrow that money, let the community carry the expense of it until further order of court, take a portion of liquidation, pay whatever taxes have to be paid, if any, and then use that money to divide equally between the parties as an advance against property, and find that it's in the best interest of the children, Your Honor, to liquidate assets to assure that their basic living expenses are maintained. And because guideline, as you know, Your Honor, you ran it, is $100 a month. And whereas here, the family as a unit was living in an upper middle class lifestyle, and their monthly nut as a family together was $15,000 net of tax. So we have to make sure that Ricky and Lucy, the little ones here, don't suffer. And the only way to do that is to liquidate assets to assure that the needs of the children are met. And you have broad discretion to deviate from guideline. We're going to ask you to do that. The alternative is to leave these children on the street. And so those are the kind of arguments that I think we're going to have to see at some point in time.
I have another issue that might come up frequently now, and that is the Pereira issue. Assuming the separate business is subject to community apportionment under Pereira, and we now have a business that may be defunct, in fact. Does the community suffer a loss in their apportionment as a result of the diminution in value that occurs as a result of the COVID-19 situation? I think there is some dictum, if you will, in, forget the name of the case, Kohler, I think it was. But in any event, that says that you could reduce the apportionment downward under certain circumstances. So I'm just wondering whether that will be considered by courts when looking at Pereira apportionments.
Well, I think the most underutilized argument in Pereira apportionment is to give the community a rate of return from data separation forward, as was done in Patrick versus Alliser. In Patrick versus Alliser 1, or maybe it was 2, I think it was 2, this is a probate case. So I know you're going to go, oh, it's a probate case, doesn't have any application. Well, wait a minute. They were talking about Pereira, they were talking about Van Camp, and they were talking about whether or not there should be a return to the community based on its apportioned share, getting a reasonable rate of return on that corpus. Let's say it's worth $1 million. How much should the community interest be assigned as a rate of return on its investment in the business? And Patrick versus Alliser says yes. And by the way, there is one date of separation in our world. That's when the parties stop living together. In the probate world, the date of separation is when one of the parties stops living. And so date of death was the date that the district court said in Patrick versus Alliser that you go back to date of death and you give pre-judgment interest to the community on its basket of investment dollars in that entity. So how does that play out today? Well, here's how it plays out. You have a blended rate based on when the data separation was. So if this data separation value was, let's say, 5 years ago, but the payout doesn't come until, let's say, year 15, but the payout doesn't come until year 20, then is it the same rate of return for every single year? In Patrick versus Alliser, the two forensic accountants agreed on what was a reasonable rate of return. They had a very minor difference, and it was in the 8% range, pretty substantial. So I could see a court saying, when presented with the arguments and the evidence to support it, that the reasonable rate of return right now is maybe a negative number, one could argue. I mean, I know that argument has been made in the past, probably to deaf ears, saying, well, I'm going to make the community bear all of the weight of that. But it certainly may be at least a 0 rate of return for the year 20 and 21, because there's nothing that could have been realized.
If I may interject for just a second, yeah. I was referring before, I couldn't remember the name of the case, but it's the Kester case, spelled Koester. And there is a footnote in that case dealing with the possibility of a reduction in value from Pereira.
In the 10 minutes we have, guys, can we address 2 issues? One is how we're going to deal with all the government benefits that have been floating around now as far as support goes, or business valuation, and then the retained earnings issue, how that's going to affect support or valuation. Maybe Drew, you want to pipe in on this?
Okay, sure. Let me start with a couple issues. The biggest issue we see with companies right now is getting the PPP loans, the payroll protection loan. And what that does, will that create any value to the company? How does it affect the valuation of the company that the forensics looking at? Well, I would first start with the presumption that it is a loan. It is a loan by the terms of the agreement. It may become a forgivable loan. I don't think it's going to create any value per se, but it may help companies hang on, and it may help them bolster their balance sheet. When we talk about business valuation, one of the things we always look at will be book value, right? And when we're looking at book value, a lot of the companies, depending on the type of company, their book value has been decimated, either through a complete cessation of revenue and profits for a period of time, or a dramatic drop that eats up working capital and retained earnings. And so that gets into, these two issues are connected, and I'm glad you connected them. Because one, I don't think there's any value created by it, but it does sustain and create an infusion of capital. Capital is always an issue in our business valuations, and it's always an issue when we're talking about pass-through companies and we're talking about distributions versus income for available for support purposes. And historically, one of the biggest issues and conflicts you had between the two experts, the forensics, would be how much capital needs to be retained in the business, how much work, whether you call it working capital, sometimes we put the moniker on it, operating capital, how much has to be retained in the company, because those retained earnings are then reinvested in the company. They're not available to the owner, the shareholder, the member, the partner. So that typically will lower the value of a company to the extent that you have to keep reinvesting and you cannot distribute out. And just as importantly, it affects the ability of that owner operator to pay support. Because if you're not distributing out those income, that operating capital, then it's not available for support. That issue has always been a friction point on bigger cases between the experts. And, can we distribute that money? Should we distribute? What's the historical policy been of the company? And the whole COVID issue only heightens that. It exacerbates that issue right now, because now clearly those who have significant retained earnings are able to weather this storm a little differently than those who constantly distributed it out and didn't keep adequate working capital. I will say one more thing, and I'll pass it off to my panelists, but it's worth the read again, and that was Marriage of Blazer. And the context was a little different, and the need for Mr. Blazer to retain money in the company was similar and different than what we're talking about today. So I'll start it with that.
I would just urge everyone to do two things when it comes to subsidies and payouts from the federal government. There's this doctrine that occasionally percolates up in family law called preemption. Preemption affects Social Security benefits. They are not property. They are a government entitlement. The subsidy checks are not income. At least you might have to pay taxes on them. I'm guessing that you're not going to. But it is not divisible property. It is determined based on you qualifying and the federal government saying, and you get this money. Now, thankfully, most of our cases, the parties don't qualify for the subsidies because they make too much money. Yippee, thankfully, right? But in cases, and I saw this on the listserv the last 2 weeks, people saying, oh, well, that's property to be divided between the parties. And I threw a shout out and said, well, I don't know, what about preemption? Of course, it's not enough money to make it worth having a serious discussion about. So what's the point? The point is go look at the underlying legislation and the legislative purpose for those dollars, number one. Number two, especially if you're going to be advising your client with regard to these matters, I strongly urge you to get someone that is a transactional lawyer who is used to looking at loan documents and has the eyesight to be able to read them without arms that are 15 feet long. And for instance, SBA loans, we're going to give you this great loan and, you're going to get this big chunk of money. And I've seen a client where they went out and got a great loan after the Northridge earthquake. And about a year later, they got a phone call from the SBA saying, we're calling your 30-year mortgage. And the answer was, what the hell are you talking about calling my 30-year mortgage? I got a 30-year mortgage. They said, read the fine print. It says, or until we determine that the needs of the SBA funding are sufficient that we need to recall your loan. So before you go advising clients about SBA loans, or even yourself for that matter, get some advice from people that really are in the know. And dare I say it, they're probably not family law lawyers, and they are probably not yourself. Get someone who actually is aware, familiar. It's great that some of our family law colleagues have started to talk about the lending ability from the government, and whether it's going to have to get repaid or not, et cetera, et cetera. We just really honestly don't know. And all we need is the next terrible disaster to force the SBA to say, well, now we need the money because there was a horrible, hurricane in Galveston, wiped out Galveston again for the third time in recent history. And so we need to call your loan because your business is doing just fine. So I've said that, I think, enough times.
One last aside on the PPP loans. Consider a business that whose revenues have dropped to, let's say, $100,000 a year, and whose payroll is $100,000 a year. They get a PPP loan for $100,000, and that is forgiven. Now they have income of $100,000.
Right. Debt forgiveness is income. I mentioned a case earlier where the court decided to use a different date for valuation than the date of trial. Now, interestingly enough, the court ordered the assets sold. And so it's sort of an oxymoron to say we're affirming the trial court's decision to value at an earlier date, but the effect of the trial court's order was, I'm ordering these properties sold. The market will tell us what that property is worth. And that may also be true in the COVID era. The marketplace is going to give us a better handle on, especially smaller businesses, what is the market for these businesses. And I think we're going to have to stay tuned for more information. The case I mentioned is Marriage of Oliveras, Oliverez, Roman numeral 2. And the case appears at 33 Calap 5th, 298. That's 33 5th at 298.
In
Marriage
the
of
last few
Oliveras.
minutes that we have, can we maybe address as a solution on the support issue, how much do we rely upon Osler Smith, or how much do we say, and then future disclosure requirements by the person who's the wage earner, or, hey, pay a percentage of your income and you're going to disclose it every 3 months as to what you're making, we'll do a true up. Is there any kind of solution in that with regard to support?
I like the true up concept better than the Osler Smith concept. I think the true up gives the parties a much more realistic amount of support because it's all a done deal. Whereas the Osler Smith is in the realm of uncertainty. You can be sure that this master has the bonus report, and you can say, okay, you got to pay 17% or whatever the case may be. But that, who knows whether that person's going to have 17% at the end of the day. So rather than go into the area of uncertainty, I'd rather wait for the period to expire, look back and do the true up, and then adjust a base support amount. Base support being an amount on which the supported spouse can reasonably live as well as feed the children.
It's an economic. Go ahead, Drew. I'm sorry.
I was just going to say, I would submit you could do both. You could do an Osler Smith and then true it up, so you can combine those concepts, I think.
Well, I would just add two things about Osler Smith and doing the true up. First, with regard to true up, I've made true up orders. I made them in 2008. And the debate is not, shall we true up? Because that's simple. Okay, we'll figure it out later, and I'll make an interim order, and we'll come back, and someone will give me the magic information that suddenly makes it easy for me to make a decision. But that's not a one-way street, in my opinion. You want to true up, you also get to true down. So there can be, and they do it in economic world all the time, clawback. We gave you too much money. Now you owe us. So before you say you want a true up, be prepared for the payor to say, yeah, and we want a clawback. And then negotiating the terms or the order for the clawback. That's number one on true up. Number two on Osler Smith. I know we're running out of time, but where's anybody going to go anyway? Right? Another Netflix, another Breaking Bad for the fifth time? Come on. So here's what it is. Underutilized in Osler Smith, and I'm ashamed to admit that it took me 40 years almost to figure this one out. But Osler Smith is a great place for a prevailing party attorney fee clause that is limited only to the Osler Smith. So if you challenge my Osler Smith, and this happens in commercial leases all the time with the pass-throughs, if you can challenge my accounting, go ahead, challenge it. But if you're wrong, prevailing party fees. And you can set, and they do this in commercial leases all the time. If your challenge doesn't yield better than 10%, you're going to pay prevailing party fees rather. Now, can I ever order that? No. The other thing I would say about Osler Smith is this. Great settlement tool, but the ones that end up picking up the pieces of your Osler Smith orders are your judges. And when are you going to get on calendar for the hearing on the true up of the Osler Smith, assuming you got that order or you negotiated that order today? So one, prevailing party fees, I think, are a good way to avoid mischief. And that includes if you don't pay me and I have to chase you to get the money, prevailing party fees. No 20-30 fees, prevailing party. Still good law that we can do that. I think it's another tool to put in the toolbox.
And I think our hour is up, but any final comments, Jack, before we let the audience go?
No, I didn't. I don't have anything more to say at this point without a specific question. So, Drew, I'll move it over to you.
Two quick comments on the topics we covered. One is just a reminder, under 2552, if you are seeking an alternate valuation date, it's not either the date of separation or the date of trial, it's any date. And we sometimes forget that. It can be any date so that the community it can be divided equitably. And sometimes we just assume one or the other. Just a reminder. And a little issue, if you look at Family Code Section 4060, the judge has discretion. If the net disposable income does not reflect an actual or a, quote, prospective amount available for support, the court has discretion to make any adjustment it likes, obviously with some evidence. Sometimes I think that's overlooked as well.
Your Honor?
I would just say what I've said in every single one of our opportunities for me to speak out to our beloved community. And that is, I just extend to all of you my very best wishes that God would keep you safe and healthy. And I believe as leaders, and we are all leaders, whether we like it or not, we lead by example, if nothing else. This is a time when anxiety is extremely high and there's a lot of uncertainty. And I'm sure many of you logged in hoping that we would have the answer, and we don't. We've got the questions that you should probably be asking. And all of what we're saying now could be vastly different by the end of the year. No COVID return, we've got one world. COVID reblossom like it's doing in China, we've got another world. The Spanish flu lasted over a period of, I believe, close to 24 or more months. So we shouldn't just say, oh, it's going to be all better as soon as our great Governor Newsom says we're going to open up the state again, whenever the heck that is. So I say, God bless you all, stay safe and well, and let's all try to be kind to one another during this very difficult time when we're all carrying a lot of personal weight on our shoulders of concern for family and others. And Brian, thank you for organizing this and providing us the opportunity to talk to this great group.
Yes,
Thank
thank
you,
you,
guys.
Brian, and thank you, Your Honor, for those
Thank
fine
you.
words.
Yes.
And thank you to the audience for attending. We hope you enjoyed it. Thank you very much.